Welcome everyone to Introduction to ERISA. Thank you all for joining us. The benefits compliance team will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We'll be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday you'll receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'll hand it over to Chase Cannon, Senior Vice President and Deputy Chief Compliance Officer of Benefits Compliance at NFP, and Patrick Myers, Vice President and Counsel of Benefits Compliance at NFP. Patrick, the floor is yours.
Thank you, Amber. Welcome, everyone. Thank you for joining us this afternoon as we walk you through the basics of one of the foundational laws for benefits compliance, which is ERISA. My colleague Chase and I will be your hosts this afternoon while we walk you through various aspects of this law. But before we do that, let me go over a brief mandatory, obligatory disclaimer, which is that this is just for general guidance purposes. This is not intended to constitute tax or legal advice. So if you've got any particular question about the application of ERISA to a particular circumstance that you are dealing with, those questions should be addressed to your legal or tax counsels. And we want to mention that the information that we're giving you today is current as of today. So here's what we're going to be covering for this presentation. First, I will provide you with an overview of ERISA itself. Then Chase will follow up with a discussion of ERISA requirements. Then I'll return and give a high-level overview of the fiduciary obligations that are imposed on plans by ERISA. Then Chase will come back and talk about ERISA enforcement, specifically the DOL's role in that enforcement, as well as discuss some of the penalties that could be imposed in the event that ERISA is violated. And then I'll wrap it up by highlighting some key takeaways from a presentation and also give you a heads up on some of the resources that we have that cover some of the same information. So let's begin with an overview. First of all, ERISA is short for the Employee Retirement Income Security Act of 1974. It was passed by Congress in 1974, and it regulates pensions and other employee benefits. The statute itself is divided into 4 titles, and Title I governs employee benefit plans, which is what we were going to be focusing on today. The DOL enforces and administers the statute, and specifically the DOL's Employee Benefits Security Administration, or EBSA, promulgates rules that help administer and enforce ERISA. And the DOL's Office of Regulations and Interpretations issues advisory opinions. Now, those opinions bind only the party that asks for those opinions, but they're often really useful looks into what the agency is thinking when it comes to the enforcement or administration of a particular issue in ERISA. So those advisory opinions are often sources for us to refer to when we have questions or we need more information. So what is the intention behind ERISA? What does ERISA intend to do? Well, we distilled it down to 3 basic objectives. First, it intends to inform plan participants and beneficiaries of the benefits and rights under the plan. They also protect promised benefits for plan participants and beneficiaries, and they provide the federal government with information on retirement and health plans. So who actually has to comply with ERISA? Well, ERISA has a very broad definition. ERISA applies to any employee welfare benefit plan if it is established or maintained by an employer engaged in commerce or in any industry or activity affecting commerce, by any employee organizations representing employees engaged in commerce or in any industry or activity affecting commerce, or by both. So as you can see, it's quite broad. Most employer-sponsored group health and welfare benefits, whether fully insured or self-insured, are going to be considered employee welfare benefit plans that will be subject to ERISA. But now that we know who may be subject to ERISA, it's also important to know who isn't subject to ERISA. So there are exceptions within the statute. Governmental plans, and that includes state, city, and county, public school, and school district plans, as well as church plans, are statutorily exempt from ERISA. Programs maintained solely to comply with state law requirements for workers' compensation, unemployment compensation, or disability insurance are also exempt. ERISA also does not apply to plans maintained outside of the U.S. or its territories for non-resident aliens. In addition, ERISA has a payroll practice exemption. This means that any benefit payment made by the employer solely out of the employer's general assets and not through insurance or other funding arrangements, usually in the form of continuing salary payments made to the employee, are exempt. To remain within the payroll practice safe harbor, the plan cannot cover former employees such as retirees, for example, salary continuations for employees out on disability. But the big one, the one that we encounter most often in our work, is the voluntary safe harbor. The DOL regulations also provide a safe harbor from ERISA requirements for certain voluntary insurance arrangements. Now, when we talk about a voluntary in this context, we have very specific meanings for that. When we say it's a voluntary benefit, what we mean is that employees pay the full premium for coverage and the employer has minimal involvement. Voluntary plans include both group and individual insurance coverage, such as life and disability insurance, dental insurance, long-term care insurance, and some types of medical bridge insurance. For example, for extended hospital stays, specified illnesses, for cancer treatment, that sort of thing. Employers can basically only collect and remit employee deductions, and even then, only on an after-tax basis, for that benefit to be considered voluntary for this purpose. And the other thing, the tricky thing about it, the one that we often see in our work, is the idea that employers cannot endorse the benefit in order for that benefit to enjoy the voluntary safe harbor. Well, endorsement includes assisting employees with preparation of claim forms, negotiating with insurers, record keeping other than maintaining like a list of enrolled employees, and permitting payroll deductions to be made on a pre-tax basis under the employer's cafeteria plan. Payroll deductions, if any, should be made exclusively on an after-tax basis in order for these benefits to enjoy the safe harbor and be exempt from ERISA requirements. This slide contains a snapshot from our publication on ERISA requirements and compliance issues by providing you with an overview of some of the more common types of plans and whether those plans are generally subject to ERISA. So as you can see, things like disability insurance could be subject to ERISA, dental plans could be subject to ERISA, but health savings accounts are not subject to ERISA, and neither are dependent care assistance programs. And finally, when we're talking about an overview of ERISA, we have to spend a moment on the idea of ERISA preemption. As a federal law, ERISA generally preempts, which is to say it supersedes conflicting state laws that regulate welfare benefit plans. However, whether a state law regulates a welfare benefit plan is not often a clear-cut determination. So, and this is an idea that is a constant source of litigation. Recently, this has been particularly the case when it comes to regulating PBMs. Significantly, ERISA preemption does not apply to state laws regulating insurance and insurers. So fully insured plans are subject to both ERISA and state insurance laws in the state from which that plan has been issued. Self-insured plans are not considered insurers and thus are not subject to those state insurance laws, and so are only really subject to ERISA. However, keep in mind that self-insured multiple employer welfare arrangements, such as MEWAs, are an exception and must comply with both federal and state requirements. So now that we've taken a broad overview of ERISA, where it comes from, who it covers, who it doesn't cover, let's move on to a look at some of ERISA's requirements. And from here, I will pass it on to Chase.
Yeah, thanks, Patrick. And such an important overview to understand what we're talking about and who needs to pay attention, which types of plans are going to have to sort of follow these requirements that we're about to get into. And, we kind of have that baseline of any employer-sponsored plan is going to fall into that bucket. That chart you showed was very helpful to specify the very specific types of plans. I would say sometimes those HRAs, health FSAs, sometimes get forgotten when we're talking ERISA. And then we have, the exceptions from ERISA. And I know you spent some time talking about the voluntary plan safe harbor, meaning it's exempt from ERISA. That one's challenging, right? Because we're talking about different potential factors that might come into play on whether you meet that. So I think that slide was very helpful. I did also want to mention too that colloquially, that's a tricky word to say, and I may have just not said it very well, but we have a lot of terms floating out there in our industry, and voluntary is one of those that often just gets thrown around, as we have voluntary plan offerings, we have ancillary coverage. And so when we're talking about those in the industry, we may not always, we maybe just be talking about a type of benefit that's generally offered directly to employees. Whereas when we're talking about that voluntary plan safe harbor, when it comes to ERISA's application, it's a very specific defined term that you just outlined. And so I just wanted to mention that as we're talking about, which plans, which employers, just because it's called voluntary in the industry may not mean it actually meets the ERISA voluntary safe harbor and gets out of these ERISA requirements. So yeah, let's get into what does this all mean? We have the employer, we have the plan, we're subject to ERISA. What does that actually look like? What do we have to do? And we're going to go through kind of 6 basic requirements here that we'll cover that you have to think about as the plan sponsor. When we say that plan sponsor, we're really talking about you as the employer in your role as sponsoring the plan for your employees. Generally speaking, these obligations will fall under your purview. You may have a plan administrator that's helping you administer the plan, that some of these tasks get delegated to. And it's possible if you're with NFP that we are helping you with many of these requirements. We can definitely do that. But let's start with the plan document and the SPD or summary plan description on the next slide, Patrick. So a plan document, this is really the most basic thing that we're talking about when we say, what do we have with a plan? A plan document is basically a written document or instrument. Sometimes in legalese, we use that term instrument, but it's just something written on paper that establishes what the plan is. Who is the plan sponsor? What are the benefits offered under the plan? Who is eligible under the plan? What is the plan year, the plan name, and the plan number? So I really think about the plan document as the operations manual for the plan. If you were to buy a new dryer and bring it home and put it in and get it installed, the operations manual would tell you how to operate that dryer. Same thing with the plan here in benefits terms, right? And so we listed here some things that need to be in that plan document that are required by ERISA, include a named fiduciary and a plan administrator, the plan year, plan name, and plan number. We'll talk about that in a minute, but that will align with what you have on your Form 5500, which is another requirement, at least for certain size plans. A description of benefits and eligibility, and how benefits will be funded. So Patrick mentioned self-insured versus fully insured, plan amendment and termination procedures, and there's some required provisions for group health plans that relate to COBRA, USERRA, HIPAA, and qualified medical child support orders, or that QMCSO acronym. subrogation and reimbursement clauses. So these are just really the operation. How does the plan pay these benefits? Who's eligible and what are the benefits is really the key points there. There is actually no requirement to distribute a plan document to plan participants. We'll talk about the SPD here in a second and what does have to go to plan participants. But employers really need to have that available. This will be the first document that the Department of Labor or a lawsuit would request when we're talking about, how could this potentially come into play down the road. So if a plan participant or beneficiary asks for a copy, then it has to be provided within 30 days. But this is not something you have to take and immediately distribute to your employees. A couple of tips here: make sure to include information about the ACA employer mandate measurement method. If you're a large employer, you have this obligation to offer affordable coverage to all of your full-time employees. And to be able to identify who's full-time, you may use a monthly, which is what most employers do. If you know what the schedule is for your employees, you know their hours, or a look back measurement method. That's getting into measurement periods and averaging a worker's hours over a certain period of time, usually a year. That is something that would need to be in your plan document. And then making sure that, plan eligibility does align with that employer mandate, that you don't say, hey, we're going to offer coverage to everybody working 35 hours or more per week. If you're subject to that mandate, you actually have to offer to anybody working 30 hours or more per week. That's the definition of full-time. So just making sure you have alignment there so that you're not kind of in violation of the law based on the terms of your plan. So that's the plan document. The next requirement is a summary plan description. If we have our operations manual, we're going back to our dryer analogy. Those operation manuals are really thick, right? But the SPD is meant to be a summary of that. And that's where we get that term summary plan description. This is meant to be a little bit more in layman's terms, informing plan participants of what are the benefits, what are their rights, how does the plan operate, and again, some of those same things with plan eligibility, claims procedures, their rights and obligations under ERISA, which include the rights to request plan documents and file lawsuits if things aren't working properly. So that is an SPD. This has to go from you as the employer plan sponsor to the plan participants, and that includes COBRA qualified beneficiaries. It includes those that would be covered or potentially covered under a QMCSO. It includes spouses and domestic partners or dependents of deceased participants if they're eligible, and guardians for covered individuals. So some interesting buckets of people that you might not think of. You would usually just think of your employees, right? So that's important. When is it due? Usually you would distribute this within 90 days for a newly covered participant. So most of the time we say distribute to a new participant as soon as possible, kind of as part of their enrollment packet. And then it should go out every 5 years if there's material changes, and every 10 years if there are no material changes. Usually you're going to have changes. We're going to talk about just a second what you do with open enrollment materials, because usually you're making some adjustments that would impact benefits at annual open enrollment. And so we'll talk about that in a minute, but that's sort of the technical under the law type of description of when the SPD needs to go to that list of people. The couple tips here: the ERISA's SPDs are not the same as carrier certificates, insurance contracts, or the summary of benefits. We'll talk about that one in just a sec. But it's possible that those documents are used to create the SPDs. And when we talk a bit about a wrap document, we'll talk about that in just a sec. But oftentimes the carrier certificates or contracts or summaries have a lot of the information that needs to be in an SPD and a plan document, but they may not have some of the ERISA required language. And so, so let's just jump to the next slide. I'll come back to that tip in just a sec. But that wrap document is one way that you can provide that missing ERISA language to the carrier certificate or policy or description of benefits to bring it into compliance with what's required under the law here with ERISA. And we call that a wrap document. We're literally saying we're wrapping the ERISA language around the carrier information policy whatever you want to call that carrier document, to make it an SPD that you can distribute to your participants. A mega rack document, and sometimes it's just called a wrap document, but another way we use that term is when we bundle several different types of ERISA covered benefits into one plan. So we may have a high deductible plan and a PPO and an HMO, and then we have a dental, vision, and some prescription drug coverage, right? That's probably 5 or 6 different separate plans if you're looking at them individually. But what you can do is wrap those together into one document, an SPD, and you call that a mega wrap document. And now you really just have one plan. Why does that matter? Well, it consolidates your administration for plan, particularly with the filing of Form 5500. You would just file one Form 5500 and list each of those component benefits as components of the plan rather than their own plan that deserves and would necessitate their own separate Form 5500. So that is a big deal. That is one thing that we encourage in most instances for wrapping documents together. It does help administratively, it does help conceptually, and cost-wise too, only having to file one 5500. The drawback there, and under our tips here, is that you may not want to include some component benefit plans might have fewer than 100 participants. If you bundle those in to your wrap document, they would now be required to be on the Form 5500. Whereas if you left them outside of that bundle or wrap document, there would not be a 5500 filing for that particular component benefit. So that we'll talk about that on 5500 in just one second. But that's one reason you might want to leave a component benefit out of a wrap plan. Otherwise, it does simplify things, and we do encourage it generally. So moving forward to our summary of benefits and coverage. This is basically a 5-page document, or sorry, it's a 4-page document that actually turned into 8 pages. But basically, the law here was to try and simplify the description of benefits so that if I'm a regular Joe employee, that I might be able to understand my benefits better. This requirement was kind of compared to a nutrition facts label on the back of a can of soup or a package of pasta, to be able to look quickly at what are the ingredients, what are the calorie levels, what are the different fat and all of those components of food. The idea here was a benefits facts label for insurance products. And so the reason we say that it has to be 4 pages, I think we have 5 pages with the table summary of plan benefits, was because this requirement was very specific in how the format of the SBC should be done, and in an attempt to kind of make it uniform across different insurance products and different plans. And so this is really something that carriers and TPAs produce and provide now. And it really should go out every year with at open enrollment. It should go at initial enrollment. If you have special enrollment, so somebody enrolls mid-year via a marriage, and that's an example of a special enrollment, and then upon request, this is something that is pretty standard now. Hopefully they look and sound familiar to you. And it does kind of play along this idea with the SPD, right? It's similar in that it's trying to help employees and participants and beneficiaries understand their benefits. But this one is in a very specific format. And again, carriers and TPAs are pretty good at providing these now. But that said, it's very important. This is our tip and our takeaway for this SBC requirement. It's very important to review those SBCs drafted by the carriers for accuracy, because we do sometimes see mistakes, and we want to catch those before they get too far down the road. So those 3 requirements, kind of the SPD, the SBC, and the plan doc, and then the distribution of those to employees at very specific time, are really, again, meant to satisfy that ERISA goal of notifying and helping employees understand what they're getting and what they're being promised, right? So now that they have those pieces of information, what happens if something changes? And that's really what we get to on our next requirement, which is our summary of material modification and material reduction. And really, this is the idea of, okay, something has changed with our benefits. Maybe we reduced what we are willing to pay under a particular cancer treatment. Maybe we've enhanced our mental health benefits for more access to more therapists. Maybe we have made a change to our cost sharing. All of these things would be pretty significant changes that if I'm participating in the plan, I would want to know about. And so there's two ways to think about that, even though there's three notices here on the screen. The first is if you have a mid-year plan change, you are going to be, if that happens outside of open enrollment and it's significant, and it was on changing information that was on the most recently provided SBC. Now you actually have a requirement to provide a new SBC with that updated information 60 days in advance of that change effective date. So 60 days is a significant amount of time, and you want to make sure that happens so that people can see that they're changing, also so that you're not penalized under the law. But it makes sense to give advance notice because people are relying on the information you provide to them. So giving them a heads up on what's changing is always important. So that would be a mid-year outside of open enrollment type of change. If you do that, you're really satisfying these other two requirements, but the summary of material modification and summary of material reduction have slightly different timeframes, both of which fall outside or after the end of the plan year in which the change is adopted. Technically, under the law, that's the rule. Practically speaking, it's not very helpful, right? Like if I get a notice 210 days after the end of the plan year and something has changed, it's changed during open enrollment, but I don't know about it, I'm going to go ahead and incur claims, and I have the right to those claims for them to be paid. And so that's just important to be able to make sure that you're following. Distributing those notices in advance. And usually we do that through the open enrollment materials, which is really what serves as an SMM or a change in benefits. So with that, let's move into, well, we had a couple of tips, I guess, on that one. Just providing that notice as soon as practical before the deadline, and that an updated SPD can sort of satisfy the SMM and SMR requirements. So I think, and Patrick, I don't know if you got ahead of me, but I think we got to talk about 5500s. There we go. Okay, thanks. So 5500s, again, part of what ERISA is trying to do, in addition to informing participants of their rights and making sure that employers pay those benefits, protection benefits, as part of that comes the Form 5500. And this is really you as the plan sponsor telling the government what the plan is all about and whether it's properly funded and who it's available to. And all that information goes into this Form 5500 report that is submitted to the Department of Labor. So it's generally used, plan administrators are responsible for making sure that the plan documents are consistent with the Form 5500. So that's, again, making sure that we don't have certain benefits described in 5500 that aren't in the plan document. Those two need to line up. But this is a filing done through the DOL, and it's due 7 months after the plan year ends. So usually we're looking at the end of July for our calendar year plans. You can file an extension by submitting Form 5558. That gives you another 2.5 months. And so again, that's driven off the end of your plan year. This is another reason that plan docs are so important, is to align plan years so that you don't get to a certain point in the year and realize you've been operating a health FSA on a calendar year and your medical plan on a 6/1 year, and now you've got to file two Form 5500. So making sure everything is lined up. But that's where we have that one wrap document equals one Form 5500 filing. There is an exemption here for small employers, and that exemption is for plans that cover fewer than 100 enrolled employees or former employees. So just look at the participant count at the beginning of the year and the beginning of the plan year. If you're unfunded or fully insured. So most self-insured plans will pay out of their general assets. They'll be considered unfunded, and then any fully insured plan would not be required to file Form 5500 in that instance. So that's Form 5500. We included a screenshot there of our guide for employers as our resource. We'll talk more about those at the end. Two more quick slides here before I flip it back to Patrick, but one has to do with the distribution method for documents. And for this purpose, we're talking SPDs and SBCs, but on a broader level, COBRA notices and other notices that have to go out to employees. Hand delivery, we kind of have three methods here: hand, mail, and electronic. Hand delivery is actually the easiest when you're thinking about the overall requirement, which is to ensure actual receipt of the notice for your employees and plan participants. But hand delivery is hard to prove, right? You hand it to them, unless you get some type of employee signature confirming your receipt, it's hard to prove because it occurred person to person. So maintain records if hand delivery is your method. It is allowed, but you just have those administrative challenges, and we don't see it used as often. Mail delivery is probably was the most common until we got into email, but let's talk mail delivery. First class mail is usually the best practice, and you should have document your compliance process. Write down in some place, what is your procedure for sending out notices? Keeping copies of address lists and notices would be helpful. Recording the dates that the documents were mailed, and just anything you can do to document your process. Interestingly, the courts do not always require that you show somebody actually was able to pull that letter out of the mailbox. They are more interested in you being able to document your processes and procedures and showing that this is a notice that would have gone out. It's even better if you are so diligent as to write down names and dates. But that is an interesting part about mail delivery. Electronic delivery is probably where we live more often now in our world. And really, it's important to follow these guidelines from the DOL. We will say that they are a little bit antiquated, but the idea here really focuses on electronic delivery being most appropriate for a workforce that has employees who have access to computers and phones regularly and are expected to check and use those computers and phones as part of their job. So really, it's harder if you have, say, a manufacturing plant where people would be on the production lines, or a trucking company maybe where they don't use computers. Those types of workforces might be more difficult. In that case, you would want to get their specific consent from an email saying that it's okay for you to send plan-related communications to them at that email. Otherwise, if they're kind of in our world where we're on computers, we're checking phones, we have all those expectations, then it's okay to send things, generally speaking, via email. But you should note that that it's an important plan document and that there's a paper copy available and how to get that paper copy. Posting to an intranet site is not generally enough to satisfy the distribution requirements here. You then need to take another step to notify employees by email, postcard, or like QR code or text message, something like that. But if you have to do that extra step, we find that a lot of employers just attach the notice to that extra step as a way to make sure that people are receiving those notices. And then lastly, how long do I need to keep things? This is kind of the last requirement under ERISA, relates to record retention. How long do you need to hang on to plan-related documents? And our general rule of thumb here is the number 8. We got there. ERISA generally requires records to be kept and made available for examination for a period of not less than 6 years after the filing date of the Form 5500. So again, that's almost a year and a half after the start of a plan year, and that's how we just kind of round up 2 years from that 6 years to kind of get to the number 8. So that's the general rule. How long should you keep those? 8 years is what we would generally say. So Patrick, that was quite a bit of me talking, but I'm really interested in your take on a requirement that is more of a method of thinking and doing things rather than a specific filing date or notice that needs to be sent at a particular time. So do you want to walk us through the fiduciary obligations?
Certainly, yes. ERISA does impose fiduciary obligations on those that administer plans that are governed by ERISA. And as Chase has mentioned, this is a much more abstract set of requirements under this statute than the more process-oriented ones that Chase has walked us through just now. And it's also an area of interest currently, especially in litigation. A lot of cases have been filed uh, regarding a plan's failure to follow various ERISA fiduciary obligations. And so there's been some increased attention on this particular area of the law. So I wanted to go ahead and walk everyone through some high level points concerning these obligations. First of all, under ERISA, parties that have or exercise discretionary authority or control over the management of the plan or plan assets are considered plan fiduciaries. Plan fiduciaries themselves are held to a high level of conduct, like that of trustees of a trust, when performing those plan obligations. So ERISA requires that a named fiduciary be specified in that written plan document so that participants and beneficiaries know who will be responsible for performing those obligations. However, fiduciary status is not based on an explicit written designation alone, but the actual functions that somebody performs could make that person a fiduciary. So it's not so much as somebody being listed in the plan document as fiduciary, but whatever the duties that that person performs for the plan may make that person a fiduciary, regardless of whether or not they're actually named in the document. And I've added here on the slide a snapshot from our publication that we released just recently that focuses specifically on ERISA fiduciary governance. That talks more about this at length. So this slide provides with a graphic snapshot of the fiduciary roles in an ERISA plan. You've got a plan administrator that is responsible for most of the compliance uh, obligations under ERISA. You have a plan sponsor who is the person who actually sponsors the entity that actually sponsors the plan itself, the entity for which the plan was put together in the first place. Usually, it's the employer. It's the employer and this plan sponsor are usually the same entity. And then there are others who could have fiduciary roles. They could be committees or other named persons in the document, or again, as we mentioned earlier, persons who have been given responsibilities that would make them fiduciaries. And they could be named in the plan document, such as, they have a title, or they could be part of a committee that is discussed in the plan document. Or as I mentioned earlier, they could be functional fiduciaries just by nature of the things that they're doing for the plan. Now, under ERISA, they have a concept regarding plan assets. And so under ERISA, a plan fiduciary has to ensure that any plan assets are held in a trust. Now, the DOL has identified three categories of funds that are considered plan assets. The first are those contributions made by participants that are paid towards plan premiums. Basically, the participants' share of the plan premium that they have to pay in order to enjoy the benefit under the plan. There are also certain amounts that are attributable to plan assets. For instance, medical loss ratio rebates and similar insurance company rebates, or settlement fund proceeds to the extent that those plan premiums were paid from participant contributions would also be considered plan assets. And then finally, funds held in a separate account or trust for the purpose of paying plan benefits are also considered to be plan assets. And so plan fiduciaries have responsibilities over those three categories of funds. Now, that said, the DOL won't enforce trust requirements to participant contributions. That is, that money that the participants pay towards their premiums, as long as those premiums or contributions are forwarded to an insurer or made through a cafeteria plan within a reasonable period of time. Now, the reasonable period of time isn't specifically defined in ERISA, but the idea is it's going to be around 90 days. The UL has indicated that around 90 days is considered to be a reasonable period of time. Now, for the exemption to apply, the employer must make payments from its general assets and not maintain a separate plan account. So if if they don't have a separate trust account that holds plan assets, and the payments for the premiums are made through the general assets, then this exemption that I've just discussed won't apply. There are a couple of other obligations or requirements that are adjacent to those fiduciary obligations that we've been discussing, and those are the requirements for a fiduciary bond and an accountant's report. Now, if you have a plan that does maintain a separate trust for plan assets, then that's when these particular requirements would apply. So it doesn't come up all that often, but when it does come up, plans really need to be aware of these requirements. So the first one is that fiduciary bond. When you have a trustee that is responsible for the trust, they have to post a fidelity bond to protect plan assets against loss due to fraud or dishonesty on the part of those trustees or other plan officials. Then, in addition to that, trusts must also provide an accountant's opinion, which is issued by a CPA firm, that says that the trust's financial records are prepared in accordance with generally accepted accounting principles, or GAAP. And this opinion would be filed with the plan's Form 5500 that we discussed earlier. So, what are the principal duties of a fiduciary under ERISA? There are three. The duty of undivided loyalty to plan participants, the duty of prudence, and the duty to act in accordance with the plan documents. Now, these duties are pretty straightforward in and of themselves, but there is a lot kind of that are implicated in these particular duties. And so we'll touch on some of that here for the rest of this part of the presentation. So the idea is that the principal duties of the fiduciary is to act solely in the interests of the participants or beneficiaries of the plan for the exclusive purpose of providing plan benefits and defraying reasonable expenses with the skill, prudence, and diligence of a prudent person in accordance with the plan documents and instruments. So the first duty that we'll touch on is the duty of loyalty. Now, under this duty, plan fiduciaries must act for the sole purpose of providing benefits to participants and their beneficiaries. Fiduciaries should avoid conflicts of interest, and certain transactions are prohibited for those fiduciaries. And those include transactions on behalf of the plan that benefit parties related to the plan, such as other fiduciaries, service providers, or the plan sponsors. Now, keep in mind that when you're hiring plan service providers, the act of hiring those plan service providers is itself a fiduciary function. So these obligations and duties must be observed when you're going about the process of hiring people to help administer the plan. And the other thing you want to keep in mind is that this duty also imposes an affirmative obligation to provide participants with adequate information in an understandable format to enable them to make informed and cost-conscious decisions regarding their plan benefits. Now, the next duty we're going to talk about is the duty of prudence. Plan fiduciaries must act with the same care, skill, prudence, and diligence as a comparable, knowledgeable plan fiduciary acting under similar circumstances. Fiduciaries must be well informed in their areas of responsibility and, as necessary, hire or consult with experts with the requisite background and experience to give appropriate advice. This duty emphasizes the fiduciary decision-making process as opposed to the results of that process. Therefore, it is important for fiduciaries to establish and follow written procedures for their deliberations. Now, again, just want to emphasize that when you're hiring those plan service providers, those experts with that requisite background and experience, that this is itself a fiduciary function. So, again, policies and procedures must be established and followed when going about that particular function. And finally, there is a duty to follow the plan document. The plan administrator must operate the plan in accordance with the terms of the written plan document, and it isn't a good idea to make exceptions or to deviate from the plan's terms as formalized in those documents. An exception would not only be a breach of the duty to adhere to the document terms, but it may also set a precedent that would need to be applied to other similarly situated employees. So that means that the plan administrator must become familiar with the specific provisions, for instance, the eligibility provisions, waiting periods, if any, under the plan. Those must be familiar with those provisions in the plan document in order to properly administer that plan. So now that we've gone over at a high level some of those fiduciary duties, let's talk about what happens if some of those fiduciary duties or indeed other obligations under ERISA are violated. So I'm going to pass this back over to Chase to talk more about the DOL and its enforcement process.
Yeah, thanks, Patrick. And really helpful to go through those fiduciary duties at a high level and understand those. We're going to focus on the DOL right now, but another way that those fiduciary obligations can be challenged is through participant lawsuits, right? And we've seen that quite a bit. We have a separate part of our Get Wise Wednesday series that's focusing more on the fiduciary governance that would impact and address that specifically. But I didn't want to ignore participant lawsuits as another avenue where all these ERISA issues could come up. But let's talk about the DOL. This is the Department of Labor. And we're talking federal Department of Labor for the entire U.S. They have authority to enforce ERISA, which we're focused on today, but also many other laws, including COBRA, HIPAA, the ACA, and some specific federal mandates that we list here that we don't have to get into. But mental health parity is a big one that is a focus right now. Newborns and Mothers Health Protection Act and Women's Health and Cancer Rights Act. These are, specific laws that give rights for specific situations. And then GINA, which is a Genetic Information Non-Discrimination Act. So lots of authority there what can they do with that? Moving into the next slide here, they really have authority to do quite a bit. And that is specific to the group health plan when it comes to those laws, but really could come in, enter a company, inspect books and records. They can ask questions. Document requests is usually the first thing that you'll see is we're starting a DOL audit on you as a company. We have a list of documents, and it can be anywhere from 1 page to 12 pages of documents that they want to see. They have the ability to subpoena documents if it does move into a court environment, compel testimony of witnesses, investigate crimes, and then, of course, assess penalties and bring civil actions. And so quite a bit that the Department of Labor can do. And so let's look at what that kind of looks like. What would an audit look like? And again, we're not trying to scare anybody. We just want to give you familiarity of how this might work. But as I mentioned, the sort of 5 steps start with that initial contact. Usually will be through a letter via mail. This is also how the IRS generally operates. But an initial contact and a request for documents. Once you respond to that, it may turn into a location visit and interviews. They may want to come out to your site and talk to people. Then it will be a voluntary compliance letter, some type of correction process, and then a closing conference where they meet with you to close out the case, and a letter that kind of resolves things. So let's look at those really quickly. We don't have a ton of time, but we'll look at each of these steps quickly. The initial contact will be by phone or letter. Plan-specific documents is usually what we're looking at. So we just talked about the plan documents, the SPDs, the SMMs. They'd also likely ask for service provider contract, insurance contract, maybe your TPA agreements, documents relating to the claims processing. A lot of these audits come out of claims that they've, maybe a participant or the DOL don't feel that the plan is processed properly. Notices, this would be beyond ERISA, but generally speaking with notices that need to be given. So a COBRA or HIPAA notice is an example. What about your reports that needed to be filed? Form 5500, our summary annual report, which we didn't talk much about, but that's after you file the Form 5500, that's the report you distribute to your participants as a summary of that annual Form 5500 report. Invoices from the carrier, and then there's some ACA specific items that we have on here, but just generally asking. Then after that, step 2 would be, again, and sometimes audits are resolved at that level if you can provide the right things and that satisfies the issue, but oftentimes it will move to this location visit where they'll do a payroll and employee census, look at accounting, look at the processes for claims, procedures, and appeals, and those communications specifically, whether notices, what are the processes? I mentioned the documentation of those processes. They may want to see those. They may want to talk to the plan sponsor or whoever those plan committee members are, if there are named fiduciaries, but then also those that are probably a little closer to the plan with HR and benefits personnel and others that are working closely with the plans. Step 3 is really after the DOL takes all that information and goes back, they will send a letter listing deficiencies with documentation of where the violation is in the law. And so a couple of examples there. And then usually you have 10 days to respond. And then from there, it becomes a correction process, giving them assurances that things will be corrected going forward. There may be corrections that need to be made going in the past. It could be modifications to certain contract terms or plan terms. And, sometimes you'll have to go to outside counsel here. But usually the audit is closed through a conference, some type of conversation and a letter saying, okay, we understand that you're doing X, Y, and Z to fix this going forward. We understand you've done A, B, and C to make it right in the past. And we're now closing our audit. And that letter will kind of say what that looks like. From there, it really moves into a discussion. Okay, well, nobody wants to deal with a DOL audit or adding on what I talked about before, a participant lawsuit, right? Both are just so full and fraught with time, energy, and money. But what does that penalty look like that the DOL could potentially assess for a violation? Let's just look at some of those numbers. Again, it depends on what is the failure. And these amounts generally, they're adjusted annually, and that generally means they go up annually. So you can see kind of 2024 versus 2025, our failure to file Form 5500 is up to 2739 a day. So think about the day after you had a due date. That is the per day following that due date penalty. Failure to provide your SBC would be a 1443 for 1,443 per failure. So if you had 100 individuals that you were supposed to send an SBC, it would be 100 times 1,443. I'm not very good at math, so I'm not even going to try that, even with a simple 100. But failure to provide information to the Department of Labor is 195 a day. There are sometimes maximums on these amounts. But just giving you an idea, the MEWA is for your multiple employer welfare arrangement. That would be almost $2,000 a day. There's a Form M1 that you are required to file. Again, that's less common, probably not applicable to most on the call today. From there, Patrick, we've only got 5 minutes, but you want to give us some key takeaways and talk about some resources, because I know we covered so much today, but we've got some really helpful resources that can recap this for you.
Thanks, Chase. Hopefully, by the time we're done here, you have an understanding of key ERISA concepts, including fiduciary obligations imposed by the law, that you have some understanding of the ERISA's written plan document basics, including the wrap document and SPD document requirements, understand the Form 5500 filing requirements, and understand the requirements for electronic distribution, In addition, a brief overview of what those fiduciary obligations are, as well as an overview of how the DOL conducts its audits and investigates potential violations of ERISA. But yes, we have covered a lot today. It's a high level overview, but it's a lot. Fortunately, we have produced a number of publications that go into these topics in more depth. For instance, we do have a ERISA compliance considerations overview publication, as well as specific publications on fiduciary governance, Form 5500 filing, as well as group health plan notices, which of course is a requirement under ERISA. So if you have any interest in those particular topics, please reach out to your NFP office, and we'd be glad to supply you with a copy of those. And so thank you so much for joining us today. We can wrap up now, and we pass it on over to Amber.
All right. Well, thank you, Chase and Patrick, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We'll be sharing out the recording in the follow-up email and on the NFP website. If there are any portions of today's call that you missed, by Monday you'll receive an email with a link to the full recording, and the PowerPoint slides used during this presentation today will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.